Deputy Durkan wants to discuss, something that he is deeply committed to, the extent to which children's welfare and well-being is protected by TUSLA in all situations in family law. Minister Burke is dealing with this.
Thank you, Cancorda. As you know, you very kindly allowed discussion on this and associated subjects over the past 6-7 months, I think eventually to the benefit of victims. And apropos the discussion we have just had, the importance of allowing discussion when none was available was of a huge groundbreaking importance. This relates to the women who are mothers who find themselves in family law situations, particularly difficult situations, and where the children have become the victims and the mothers, sometimes the fathers, but more especially the mothers, become the victims, and that they are removed from the custody of the mother and placed in the custody of the opposing party. And that's done on a regular basis. Almost 90% of the cases that happens with the same result and the same procedure followed. Invariably, the women in these cases appeal to the system to help them out. The system in this case is TUSLA, whose responsibility it is to protect children. And we were admonished in previous eras for not listening to children, for not believing children. But we have situations, and Cancorla, where the children haven't been believed. And even TUSLA have said they don't believe the children. Well, that's not their function, because the issues have to be before the courts. Nobody can interfere. That's not true. That's unconstitutional, of course, but if anyone was to take a case. But the point about it is the unfortunate women in the situation to which I have referred are in no position to take a constitutional case because they don't have the resources. And the next part of it is simply this. It will continue as long as it's allowed to continue, just like the last subject that we have discussed. So I am seeking an inquiry into the whole system, both insofar as TUSLA are concerned and the family law courts are concerned. Because if it doesn't happen soon, there will be tragic circumstances, there will be tragic ends to the situation, because children are in some cases put in a cell away from their mother. Their mothers in some cases have been put in cells away from the children, just to ensure the children have been arrested and placed in a so-called place of safety, where there were previous allegations to the contrary. And it still goes on. But the thing most annoying, I think, is the fact that TUSLA feels it cannot intervene on the part of the children. Yet that's TUSLA's job, to interfere in the part of the children. And in one situation, as I said, the TUSLA employee said, "I don't believe the child." A very serious remark to make in any such situation. Who is going to believe the child? How will the child or the children in those circumstances get any kind of protection? They can't, of course, because there are too many oars in the water, for want of an expression. So I would say that, the Minister, I thank you for coming into the House to address the situation. I know that you're familiar with the situation because I brought it to your attention beforehand as well in relation to your own constituency, and just in case that the occasion mightn't be. This is an important occasion. This is an important occasion. It will have a groundbreaking effect, and it will be followed indefinitely. Thank you.
Thank you, Deputy Durkan. Minister.
Thank you, Count Corla, and I thank Deputy Durkan for raising this very important issue, which I am answering on behalf of the Minister for Children, Equality, Disability, Integration and Youth. Under the Childcare Act 1991, TUSLA, the Child and Family Agency, is a statutory body with responsibility to promote the welfare of children who are not receiving adequate care and protection. The Act is a key piece of legislation whereby the state, as a last resort and for the common good, may intervene to take the place of parents as provided for under Article 42A(2)(1) of the Constitution. TUSLA can apply to the court under the 1991 Childcare Act for a number of different orders when it believes that children are at risk or in need of care. These orders give the courts a range of powers, including decision-making regarding the type of care necessary and access to the child or children for parents or other relatives. In such cases, the court has the power to direct TUSLA regarding the care of the child. Under this Act, the court must regard the best interests of the child as the paramount consideration. Section 26 of the Childcare Act 1991 provides for the appointment by the courts of a guardian ad litem in respect of childcare proceedings. The courts are subject only to the Constitution and the law, independent in the exercise of their statutory functions, and the conduct of any family law case is a matter for the presiding judge. The programme for government contains a commitment to enact a family court bill. The family court bill will be a key element in the development of a more efficient and user-friendly family court system that puts families at the centre of its activities, provides access to specialist supports, and encourages the use of alternative dispute resolution in family law proceedings. The Minister for Justice received government approval in November 2022 to publish the Family Court Bill and the first National Family Justice Strategy, marking a significant step forward towards reform of the family justice system. The Department of Children is represented on the Family Justice Oversight Group, led by the Department of Justice, and is closely involved in the planned reforms, particularly as they relate to childcare proceedings and in ensuring that children's best interests are central to this process. Minister O'Gorman, as dedicated Minister for Children, is committed to upholding the best interests of children in all situations. Ireland held the presidency of the Council of Europe in 2022. One of the priorities chosen for the Irish presidency was Hear Our Voices, which had a particular focus on youth engagement. As part of this, Minister O'Gorman was delighted to host a conference in October 2022 focusing on the rights and determination of the best interests of child in parental separation and in care proceedings. Last year, the Minister oversaw the enactment of the Child Care Amendment Act 2022. The main purpose of the Child Care Amendment Act 2022 is to extend and regulate the guardian ad litem system for children involved in childcare proceedings. The provisions of the Act are intended to enhance the rights of children and the capacity of the courts to make the right decisions in helping children and their families. The bill provides for reform of the guardian ad litem arrangements in childcare proceedings, addressing significant shortcomings in the current system and providing a presumption in favour of appointment of a guardian ad litem in all childcare proceedings. However, private family law is not covered by this legislation. Legislation related to private family law is under the remit of the Department of Justice, and Section 32 of the Guardianship of Infants Act 1964, as inserted by Section 63 of the Children and Family Relationships Act 2015, provides that a court may appoint an expert to determine and convey the child's views, known as Voice of Child report.
Durkan.
Thank you, Minister, and thank you again, Can Corla, for facilitating this particular debate. The problem is, of course, the two departments act independently. And as long as that happens, this abuse will go on. This controlling will go on. This bullying will go on. And this attempt to disregard children. And in one case, it was said, I have come to a conclusion. I don't believe what the child said. Well, you know, that's a strong statement, particularly after all the things that have happened in this country. And I would challenge the right of anybody to come to that conclusion. And we've all dealt with these family law cases at our various constituency clinics over the years. And it doesn't take rocket science to come to a conclusion as to what's going on in certain circumstances. And I think that as the matter drifts along, my intention is to bring it to the next stage, whatever that stage may be, if it isn't dealt with in the way that it should be dealt with, resolutely and quickly, in order to protect both the women and their children, because there should be no situation where the kind of things that have been brought to my attention are being allowed to happen unchallenged.
Thank you, Deputy Durkan. Minister, to conclude.
Thank you, Count Corlin. Again, I thank Deputy Durkan for raising this important issue, and I know he has raised this on a number of occasions. And I will revert back to the Minister for Children with his concerns, because obviously there are very serious issues that he's bringing to public attention in the Dáil, which is the highest forum in the country to do this, and I will refer back to the Minister on it. Thank you.
Thank you, Minister Burke. And I suspect Deputy Durkan's not going away as far as this matter is concerned.
Thank you, Ken Corlin.